Welcome back to our podcast series on blockchain, tokenization, and crypto assets. I am Sotiris Kolelis, and I'm here with the usual suspect, Dr. Anastasia Mallerou. Welcome, Anastasia.
Hello, Sotiris.
In the previous episodes, we explored what blockchain is, the legal challenges it raises, and the different types of blockchain architectures. What comes next?
Well, I'm thinking of moving a level deeper into one of the most transformative elements of blockchain technology, smart contracts.
Great, let's dive in. So what is a smart contract?
A smart contract is fundamentally software code stored and executed on a blockchain. The code automatically performs certain actions when predefined conditions are met, such as transferring a token, releasing collateral, or granting access to a digital asset. We can think of it as a digital vending machine. Once you insert the right amount of money, the machine automatically gives you the product without any further negotiation or room for interpretation. Smart contracts usually consist of the code that defines the logic, the data on which the code operates, and the triggers or conditions that activate the execution of the contract. As they operate on blockchain, we find in smart contracts both the strengths and the challenges of decentralization.
Why do smart contracts matter?
Smart contracts are important because they enable automation. They reduce the need for intermediaries, lower the risk of human error, and can make transactions faster, cheaper, and more transparent. For industries like finance, supply chain, intellectual property management, and others, this automation can radically reshape existing processes.
I understand that they operate in a fully automated manner. Is that so?
Yes, absolutely.
And what happens if, for example, the parties change their minds?
This is a very good question. Unfortunately, automation comes with a great degree of rigidity, and this creates some novel legal questions. For example, how will a case of force majeure be dealt with in a smart contract? Or what if the parties do not have legal competence, and so on?
I see. So are smart contracts legally enforceable, or can they be?
To answer the question, we must make the distinction between a smart contract code and a legally binding agreement. Sometimes a smart contract is indeed the contract. More often, however, the smart contract is just a tool implementing a wider legal agreement. In the latter case, we can of course apply the criteria of the law for assessing the validity and enforceability of contracts. In some jurisdictions, and Greece is one example, specific legislation has been adopted to clarify the enforceability of smart contracts and their use as means of proof before the court.
The code may automate performance, but it cannot express the intention of the parties or the purpose of the agreement. It does not provide grounds for interpretation.
That's right.
So, how are ambiguities solved? In traditional contracts, we apply general principles like good faith, or we look for evidence of the party's intention in the negotiation phase. I understand that this is not the case with smart contracts.
No, it is not. A smart contract will execute exactly as written on the code, even if the outcome is absurd or illegal. You see, smart contracts are not always so smart and are not in touch with external information. This is where oracles step in.
Yes, we often hear the term oracles. What role do they play in smart contracts?
Good question. A smart contract can only see the data that exists on the blockchain, but many contractual obligations depend on external information. For example, the price of a commodity, the delivery of goods, or even the outcome of a sports event. Oracles are services that feed real-world data into the blockchain so that smart contracts can act based on it. Of course, oracles introduce new risks. If the data fed to a smart contract is inaccurate or manipulated, the contract may be executed wrongly. So, oracle reliability is a major legal and technical challenge. We'll come back on this in one of our further episodes.
What happens in case of a bug or a technical failure? Who is liable when something goes wrong?
We don't always have a clear answer to this question. It will depend on the case and, of course, on the applicable law. It may be the developer who wrote the code, the deployer who put the contract on chain, the user who decided on the terms, etc.
Do we then assess liability based on the same criteria we use in traditional contracts? For example, the degree of control that each party retains, or whether deployment is offered as a professional service, etc.
These criteria do apply. However, as this area evolves, I also expect that legislators and the courts will develop new standards or provide new interpretations of notions like negligence, duty of care, etc., for decentralized systems.
In one of our previous episodes, we said that blockchain is typically immutable. Does this immutability affect smart contracts? How can errors be corrected?
This is a good point. Once a smart contract runs, you cannot undo it in the same way that you can unwind a mistaken or misrepresented traditional contract. Typically, a new smart contract would be required for this purpose.
In view of all this, I'm wondering whether smart contracts are widely used in transactions.
Well, despite their drawbacks, smart contracts are already widely used in many sectors. In the supply chain management, for example, smart contracts are used to release payments when goods move through certain checkpoints. Smart contracts are also used to automate the transfer of tokenized shares or for the use of digital assets as collateral.
So, if someone wants to deploy a smart contract today, what would your big... if someone wants to deploy a smart contract today, what would be your key piece of advice?
I would say never treat code as a full substitute for legal drafting. Use a smart contract as tools, but ensure that the rights, obligations, and remedies of the parties are recorded in a legally enforceable agreement. And, importantly, involve both legal and technical experts early in the process. Smart contracts sit at the crossroads of law and technology, so neither side can stand alone.
And how should we, the lawyers, approach smart contracts?
As legal professionals, our role is to bridge the gap between traditional legal frameworks on the one hand and automated execution and decentralized structures on the other. Many questions relating to the decentralized character of blockchain arise, as we already said, in connection with smart contracts.
Very well said. Thank you, Anastasia, for expanding on all these points.
Thank you, Sotiris.
Thanks for listening. Stay tuned for our next episode in our series of blockchain, tokenization, and crypto assets. If you would like to find out more information about this matter or any other legal matter you may have, visit www.bernitsaslaw.com or reach out to us directly.
This is Bernitsa's Law Podcast, your window to the latest legal developments in Greece. This podcast is intended to provide general information and is not meant to constitute a comprehensive analysis of the matters or to be relied upon as legal advice. It is not meant to create a lawyer-client relationship. Legal and other professional advice should be sought before applying any of the information in this podcast to a specific situation.